Hello everyone, welcome to this video looking at contract disputes and resolution. We'll be looking at some of the common causes of contract disputes as well as both simple and complex dispute resolution processes. So if we start with the question of what causes contract disputes, obviously this is almost an infinite number of potential contract dispute causes, but there are some major categories which are quite common. So some of these can be tackled as part of a robust and well-planned procurement cycle, and others unfortunately can occur even in very well organized procurement processes. So specification and scope of work is one thing that can be tackled early on in the procurement cycle. So if you have a loose specification or a loose muddy scope of work, that's obviously a dangerous source of contract disputes. If the procurer and the supplier are not clear on what's actually being specified in the contract, what the actual work that's being done is, then really it should be no surprise if there is a dispute that arises from that, simply because the structural interest of the supplier is to do the minimum amount of work for the maximum revenue, and obviously that's reversed for the procurer. So having a clear scope of work and clear specification is the ideal situation, but where the specification isn't clear because of the complexity of the service or items being procured, or because there's several potential solutions, then using an appropriate contract type or using an appropriate procurement conducting procurement method would really be necessary in order to minimize potential disputes in the future. Perception of suppliers' performance as well as personality clashes can arise, however, even in well-organized procurement processes. Those really come down to the individuals involved. They can come down to external factors, stressful environments, miscommunication, language barriers, all kinds of things. So not everything can be directly involved or directly tackled early in the procurement cycle. Some things can crop up during the actual service being provided or the items being provided by the suppliers. Some of these other items, however, can be tackled contractually rather than just during the planning phase. So if you consider changes and variations to the contract, a well-written, well-planned contract with appropriate terms and conditions can build in particular points to tackle any needed variations and provide a framework for any changes. This requires a degree of foresight and isn't always possible. However, it is something which the benefit of experience, particularly if the procurement cycle is a repeating cycle, or there is experience within the organization on what changes and variations are likely to be needed, that certainly can be controlled for. Prices and payment really derive from two things. One is a robust negotiation process where it is not just purely an adversarial negotiation, but rather one that seeks to harmonize the interests of both as far as is possible, as well as having appropriate contract types in place. So the payment processes are actually designed to maximize performance and harmonize interests. So again, that's something that can be handled within the contract negotiation and drawing up the contract itself. Third-party involvement, particularly subcontractors, are a major source of contract disputes, particularly when boilerplate or standardized terms and conditions are used, which don't necessarily always have clear guidance on the use of subcontractors. There is no need to include language around subcontractors within a contractual agreement. However, if this isn't done, this really does open up potential major contractual disputes. So that again should be tackled at the contract stage ideally, otherwise it can and does lead to significant contract disputes. So we have a range of major areas here, some of which really are to do with individuals, personalities and circumstances. So there is always going to be the potential for disputes to arise. Others are concerned with the planning actually inherent within the procurement cycle, so we can minimize those sources of contract disputes during the planning phase, and some are down to the contract and the level of detail and clarity contained within the contract and various terms and conditions that are included. We will be looking at terms and conditions in more detail fairly soon on the unit. Now, before we start looking at more complex formal ways of resolving contract disputes, we're first going to take a look at a simple conflict management approach. So the first step in any kind of conflict or any kind of dispute between two entities really should be to try and resolve this at the operational level. So escalation may be necessary, and certainly there are both formal mechanisms as well as obviously the nuclear option, which is litigation through the court system, but operational resolution would be the preferred method of resolving the dispute in almost every situation. So to do this, we have a nice simple conflict management approach, which is mostly common sense but is still worth going through. So the first step would always be to establish facts. This would be sometimes overlooked, even if it seems like straightforward common sense, in that in many cases the interest of the party that you belong to, whether that's the supplier or the procurer, tends to cloud your judgment. So establishing facts would be an important first step, just to have a understanding of what's actually at stake and what actually occurred, particularly if there's a potential for the dispute to escalate and go to formal mechanisms. Then factual information and establishing firm facts is absolutely necessary and should inform your behavior moving forward as well. So once you have an understanding of what's actually caused a dispute, what factual issues are at stake, you'd move on to evaluate the particular situation. Again, bearing in mind that if there is an escalation of the dispute, then there has to be a reasonable attempt to understand what's actually happened, and a reasonable attempt to behave in a manner consistent with the factual information. So trying to avoid seeing this as an adversarial relationship may seem odd since we're talking about conflicts and disputes, but bearing in mind that when things are escalated, particularly if we bring in things like arbitration and litigation, then behaving in a manner which is consistent with the established facts is particularly important. So you'd want to evaluate the situation, but alongside evaluating the situation, we would also need to evaluate the relationship. And this is important. Unlike other types of interpersonal conflict, a contractual dispute really is a dispute within a relationship that's been established through the contract. So as well as the immediate situation, which may need an immediate resolution, you also have the consequences for the contractual relationship. So not just the long-term contractual relationship. So if it's a supplier that has multiple contracts with your procurer, then you have that long-term relationship which needs to be considered, but also the relationship over the life of that specific contract. So both the immediate situation and the relationship as a whole needs to be examined and evaluated. This doesn't need to be massively formal, but this does need to be something that you consider and bring into your behavior and your approach to the dispute. Once you have evaluated this, then that should lead quite naturally to having set objectives for your side of the dispute. So whether you're representing the procurer or the supplier, this should be the objectives that you have going into trying to resolve the conflict should be based on these three prior items. So your behavior and your objectives should be logically based upon the factual information of what happened. They should be based on your evaluation of the immediate situation, but also your evaluation of the overall relationship as well as the relationship over the duration of the contract. Those should all feed into having set objectives. So whether it's being flexible or giving way on the immediate situation in order to preserve and prioritize the contractual or long-term relationship, or vice versa. This is something that you'll be able to do once you've actually considered all the relevant issues at hand. Then once you have your objectives determined, we can go forward and actually conduct the meeting itself. So you'd have a sit-down meeting, or in these apocalyptic coronavirus times, a Zoom meeting of some description. Then you're not going in with an adversarial mindset. You're not going in order to try and further the conflict or allowing emotions to determine your behavior. You're going into the meeting with clear objectives built upon sound reasoning, hopefully. That's no guarantee of actually getting the conflict resolved, but it does protect you and the party that you represent or you're a part of. If the dispute is escalated, if you're able to establish that your behavior and your conduct was in fact proportional and was in fact consistent with the situation as it happened. Ideally, that would lead to a negotiated resolution, and there's no need for escalation. But obviously, in many cases, the behavior of the individuals may be irrelevant if the disputes are arisen from something structural, arisen from some other external circumstance or external event, and also arisen or furthered by the behavior of the other party. So although this is a wonderful first step and always should be followed, simply because any escalation has an increasing burden and imposes increasing costs on both sides, and that's not just necessarily in terms of the performance of the contract. It can also have impacts in terms of cost, so financial cost, employee time, knock-on effects on projects and operations, leading to customer goodwill, and really could rapidly escalate. So ideally, you'd want to resolve disputes speedily, quickly, and effectively at the operational level. However, in many cases, it may be an escalation to formal dispute resolution processes may be required. So if we start at negotiation, which is what we were discussing in the simple conflict resolution model, once you've attempted to resolve through operational contact, the next step logically would be escalating to higher management levels. So kicking the can upstairs effectively is a necessary step, but a fairly logical one. But you'd have a similar attempt at resolving the conflict through senior levels, with the same evaluation of the situation along with an evaluation of the relationship, leading to the establishment of objectives and an attempt to have meetings and interactions to come to a common understanding. So if you presume that's also failed, then we have a range of additional dispute resolution processes that we could use. Mediation and conciliation are two that would be just above operational and managerial negotiation. So this is still a negotiation. There's no judgment that is imposed. So a mediator really is running an assisted negotiation, would be one way of phrasing it. The mediator doesn't impose a clear decision on parties, so does not actually make any judgments. They are not like an adjudicator or a judge. Their role is not to propose solutions or take active suggestions, but simply to provide a neutral third-party presence, which may assist in actually breaking down communication barriers, cooling tempers, and focusing minds on finding a solution as a whole. There is also no real need for the mediator, because of their limited role, for them to have any significant insight into the industrial, professional, or sector problems or related issues that may be at hand. So a mediator doesn't really need to have an insight into the actual conflict itself. Their role is not there to really pass judgment on behavior or to make suggestions, but rather just to provide an environment where a negotiation can occur. There is mostly still the same for a conciliation process, but there are still some significant differences. So here, a conciliator, generally speaking, will be a member of a professional trade body, so they will have some insight into the actual material relevance of the dispute or related facets of the dispute. So there is additional insight over most mediators, although mediators can also share those same insights, but there's no real requirement to do so. And this is because a conciliator can actually take a slightly more active role in the negotiation. So proposing solutions, for example, absolutely can be one way to try and move forward. And this is because conciliator really does take the approach of attempting to reconcile the parties, hence the term. So particularly helpful if the two parties are involved in a relationship where they both wish to continue. So there's a blockage on the relationship, there's a contractual dispute, but both parties have a structural interest and a stated interest to actually try and resolve the issue in order to resume their relationship, to resume both contractual relationships as well as long-term relationships. So the goal of the conciliator is not just trying to find an immediate solution to the dispute, but also to reduce tempers, to drain some of the emotional charge from the situation, because there is a stated goal to try and resume the relationship as a whole. So if a situation has occurred and a dispute has arisen, there can be an attempt to resolve the dispute in order to free the parties of their respective obligations to effectively bring the relationship to an end. However, a conciliator will be orientated towards resolving the situation in such a way that the relationship doesn't need to be abandoned, but actually can continue and indeed in many cases strengthen. So those two are closely related, so mediation and conciliation, but the next two will be a significant step up, and presumably the dispute would have escalated to the point that mediation and conciliation, representing assisted negotiations, was not sufficient or is not sufficient to resolve the dispute. So with adjudication and arbitration, we're not just involving someone to assist us or to make suggestions or to reduce tempers, but actually to make a judgment. So to hear the dispute and find a solution, and to essentially pass judgment in order to impose a solution, although the word impose is one of the key differences between the two. So for an adjudicator, an independent third party that must have a degree of expertise, so cannot be someone that has no idea or no clue what the material facts of the case are, of the dispute are, or has no understanding of the surrounding situation around the dispute. So they must have a degree of expertise, or at least some degree of insight into the dispute itself, would hear the arguments from all of the involved parties, would adjudicate or make a judgment, but there is significant limitations on this judgment. So costs cannot be awarded, there is no ability to impose fees or to impose payment terms, and also the judgment isn't strictly binding. The judgments can be challenged and can be escalated further. Now, because of these limitations, adjudication does tend to be quicker than arbitration or litigation, so there is significant advantages in speed, and also there is that flexibility in continuing to escalate or take the dispute further if one or both parties are not satisfied with the judgment of the adjudicator. Now, arbitration and litigation obviously can be challenged as well, but there is far more limits on how you would appeal, on what grounds you could appeal an arbitrator's decision or the decision of a judge. With an adjudicator, because the judgment is not binding, explicitly not binding. It is easier to appeal. It is easier to take the dispute forward and continue to escalate if that's seen as necessary and appropriate. So the alternative to adjudication, but still avoiding the court system, would be an arbitrator. And with arbitration, you would still have an independent third party here. It's worth pointing out that arbitration in many cases is contractually required, and this is because although it may take significantly longer than adjudication, I think with an arbitrator you're looking at really a couple of months at least, but adjudication can be resolved within 14 days or under 30 days, which is usually the goal of an adjudicator. So this is kind of set out nationally in many cases, an Arbitration Act of 1996, where there is some facility to appeal to the High Court, but generally speaking, an arbitrator has significant ability to resolve disputes and to impose judgments. So judgments can be made to award costs. So there is the ability to order payment, for example, if that's a judgment of the arbitrator, and there is a limited ability to challenge decisions. So there are some significant grounds that decisions can be challenged on, and that's essentially process based. So if there is a clear deviation in the process used by the arbitrator, if they clearly have not taken into account certain facts of the case, if their judgment doesn't reflect the process laid out by the Arbitration Act of 1996, although don't quote me on that, then there are grounds for appeal, and that appeal can move straight to a high court in the UK. However, dissent from an arbitrator's decision based upon unfairness is not possible. So you cannot challenge the decision of an arbitrator based upon something which is not something which is part of the actual process of arbitration. So if there is a process flaw or a something being missed or something clearly faulty in the process to reach a decision, that is grounds or limited grounds for appeal. But anything which is not part of the process but based upon the judgment itself, i.e. the arbitrator was biased, the arbitrator shouldn't have judged in this way, the arbitrator was being unfair, all of these things will be dismissed and are not grounds for appeal. It is worth stating that in the previous cases of mediation, conciliation, and even adjudication, both parties or all the parties involved obviously have to agree to go forward and meet in an associate negotiation with an mediator or or even an adjudicator, and this is broadly the same case for arbitration. There has to be consent and agreement. However, in certain industries, there is a legal mandate to go forward to arbitration, so it's necessary to go and get a dispute resolved by an arbitrator. And in other cases, it's actually built into the contract that when you agree to the contract, one of the terms of the contract is that you're agreeing to binding arbitration in the result of a dispute. This is increasingly becoming common in consumer contracts, so in sale contracts between businesses and consumers, that in the light of a dispute, and that the consumer has already agreed when they agreed to the contract to go forward and have the dispute heard and a judgment passed, a binding judgment passed by an arbitrator, rather than directly suing the business involved or going straight to litigation. So arbitration is a formal process, and there are significant number of situations where it is a required process itself. So in many cases, the binding judgment by the arbitrator will end the dispute and there'll be limited abilities to appeal. But where there is an ability to appeal, or if there is any kind of scope for litigation, where one party clearly wants to push forward for litigation, then this would be the nuclear option, so to speak. This is the highest form or the most formal form of contract dispute escalation. It is really not an ideal way of resolving the vast majority of disputes, and there are some major reasons for doing so. So there is some obvious benefits to litigation. It's absolutely binding. Courts absolutely have the power to impose fees, to order payments. So it can be used to resolve significant major disputes with significant cost components. However, the downsides are quite major. So the first would be the sheer amount of time that can be taken up by litigation actions, both in pre-trial motions and lengthy waiting periods before courts will actually hear a particular case. So there is a huge backlog in the UK, and this is the cause of a lot of hand-wringing and various attempts at resolving this backlog. But this means that litigation is not a quick option. So if you are looking to resolve a dispute and resume a relationship, as well as obviously the emotional charge of being taken to court, there's also the practical matter of the fact that the relationship will be on hold for a very lengthy period until the courts actually hear the case. So it's really not suited for a situation where a dispute has arisen and there is a desire to resume the relationship. A conciliator, so conciliation or mediation or even adjudication will be far more appropriate in those cases. It's also really not appropriate for anything which has limited cost implications simply because of the expense of litigation. Now, you may have heard crazy stories about legal costs being awarded here and there. Those generally don't come from the UK. If you've grown up on John Grisham novels like I have, then you've also grown up hearing about crazy judgments where both legal costs are completely awarded, and also there will be significant punitive damages. The UK courts don't have this approach. Actual damages and consequential damages can and often are awarded, but punitive damages, which are aimed at punishing the party and setting public examples, are often not considered. This is not part of the UK or the English common law system, and there is an ability to recover legal costs, but in a fairly limited manner, where the legal costs themselves are often mandated and established, and only certain circumstances are eligible to have the losing party actually paying the winning party's legal costs. So even if you were to win your case, if you pursue litigation, there's no guarantee that you're going to be able to have your legal costs actually covered. Or if you are confident that you will win the case and you do actually fall within some of those circumstances where you can recover legal costs that may well not cover everything or only partially cover the costs that you've paid out. So for litigation, the dispute really has to involve substantial sums of money or be of substantial importance to the organization in terms of its actual strategy or strategic position. Otherwise, simply the costs and the time alone would rule out litigation as an appropriate option. We can add to this as well the absence of confidentiality. Litigation and courts in the UK the purpose isn't just to serve justice, but also to be seen to serve justice, which means that if cases are heard in court, court records do exist, things will be recorded, and things will be open to the public in many cases, although again, in certain circumstances, a judge can and often does decide to restrict the information made available, but the principle is of transparency, which means that while arbitration is often confidential by process, and there's no list of arbitration judgments that you can easily access and go through and see internal dirty laundry from companies. Same way, mediation, conciliation is as a rule confidential, as is adjudication. Litigation is not confidential. The principle is that of confidentiality. The principle is that of transparency. Sorry. So that means that depending on the nature of the dispute, that also may rule out litigation as a suitable avenue to resolve the dispute if it is involving sensitive matters, or if it's information that the party doesn't wish to be made public. And lastly, litigation will end. There will be a judgment made one way or the other, and this is made in civil cases on the balance of probabilities. If you remember the famous phrase, which again, if you've grown up on the bill, which reminds me, I wonderful show from my childhood. The whole beyond reasonable doubt is the standard for judgments in criminal cases, but in civil cases is simply balance of probabilities. That itself can potentially raise questions as to whether litigation is really the appropriate course of action. You have significant freedom in adjudication and arbitration, as well as in mediation and conciliation, to find mutually acceptable solutions when it comes to litigation, because of the nature of the court system in the UK, which is adversarial. So the judge doesn't have an investigative role like you do in legal systems like France, where magistrates often act as investigators, but rather the judge oversees an adversarial process between legal representatives of the parties. This often results in the potential for a lose-lose situation, where the judgment that's handed down is actually negatively perceived by both parties. That's not going to occur with mediation or with conciliation, simply because those are assisted negotiations, and it would be extremely strange if an assisted negotiation resulted in a resolution where all parties are deeply unhappy. That can and often is a very real risk with litigation.